Lonce LaMon for June 29, 2012. Welcome to AdjusterCom News and Part 2 of Sex, Marriage, Criminal Charges, and the Firing of a Company Man. Okay, Richard Widom was fired on April 22, 2009 after a 30-plus year career with the Stockwell Firm. Stockwell Firm is a 60-year-old institution in workers' compensation claims defense. Okay, Richard Widom joined the firm in 1978. Lisa Kerner, another attorney with the Stockwell Firm, joined the firm in the 90s. They got married in 2005. 2009, they got in a fight, a physical altercation. She alleged domestic violence and domestic abuse, and the you-know-what hit the fan. She filed criminal charges. She filed for a temporary restraining order, a permanent restraining order. She filed a civil tort case, and Widom was fired on April 22, 2009. So think about this. There's a 7-week period between March 1st, 2009 and April 22nd, 2009. Imagine the turmoil that was going on in the Stockwell office during these 7 weeks. This happened in the Los Angeles office. Richard Widom, Lisa Kerner, Steve Harris, and George Wolverton all were in the LA office. The LA office is in a building around the 3800 block, Mid-Wilshire. So imagine the turmoil. Imagine how the Stockwell Firm may have feared the repercussions of this event and possible lawsuit from Lisa Kerner. After all, Richard Widom was a partner in the firm, and according to her, he beat and battered her. So it took the firm 7 weeks to fire him. I mean, did he go to work every day for those 7 weeks? Was Lisa Kerner there in the office at the same time as Richard Widom? Did they pass in the corridor? I can't even imagine what things may have been like for that 7-week period. But Widom was fired. Also, another thing that I think is important in this case is the sensibilities of our society. If ever there's an allegation of domestic violence, the man can never stay with the firm and have the woman get fired. Our sensibilities, and especially masculine sensibilities, always favor the woman. The woman is protected. In any kind of a physical fight, hey, the woman's at a disadvantage. One of the things I tripped on is when the judge commented when he denied Lisa Kerner the permanent restraining order, was that she admitted that she slapped him. The judge made that statement. And I was thinking, okay, big deal. So she admitted that she slapped him. There are so many movies where the woman slaps the man, or slaps him across the face. And if a man strikes back with a fist, it's certainly not the same thing. It's certainly not a level playing field. I remember in the 7th grade, I think I slapped a boy for the first time when he insulted me, verbally attacked me, and really attacked my feminine honor. There's a sensibility in our culture about a woman's feminine honor. And a woman has a right to slap a man, and he should take it. I remember the principal of the junior high told my father that I needed a psychiatrist, and my father said, oh, horseshit. And my father was outraged because he was a man of his culture who believed that a woman had a right to defend her feminine honor. So I thought of this when I read the part where the judge said, oh, Lisa Kerner admitted that she slapped him, and it was as if her slapping him would ameliorate Richard Widom retaliating with a fist in her face. That would not be appropriate, and certainly any man who gets slapped should be able to take it. So it wouldn't ameliorate it in my mind. Anyway, moving forward, what happened in about June of 2009 is that Richard Widom filed a civil complaint against the Stockwell Firm. Okay, he claimed that he is owed deferred compensation. He claims that he is owed $4 million in retirement benefits. Also, he's claiming punitive damages. He claims that he's suffered loss of economic advantage, loss of business, and that George Wolverton especially badmouthed him. Richard Widom alleges that he was badmouthed to prospective clients. There is some language in the complaint about Kroger, that George Wolverton told Kroger that Widom was under investigation for a criminal matter and that he was going to be put on trial on criminal charges, and he would be all sucked up in this litigation, and that much was communicated to Kroger, and then Widom didn't get on the panel. So he claims punitive damages, and that Stockwell acted with malice. Okay, well, Stockwell did assist Lisa Kerner in filing the criminal charges, and they hired a private investigator. Well, the discovery referee really favored Richard Widom, and here's what I read that he was thinking and feeling. He felt that the Stockwell Firm had a real self-interest in not paying Widom his $4 million in retirement benefits, that they are very financially motivated through this lawsuit in not paying him this money. So that's why they acted with malice. And the trial court bought the opinion of the discovery referee. Well, the appeals court overruled this and said no. The Stockwell Firm did not act with malice according to the appeals court decision, and here's why they think that. There is a rule that anyone can communicate with the police, can communicate with the cops, can have a private investigator communicate with the cops and give them information and not be sued for punitive damages. The law wants to protect the right of anyone to communicate and to keep the avenues and the lines of communication open without fear of being sued for punitive damages. So the appeals court found that the Stockwell Firm did just that, that they in good faith believed that Richard Widom beat and battered Lisa Kerner, and in good faith George Wolverton made certain statements to people, and in good faith they communicated to the police, in good faith they communicated to the city attorney, to the district attorney, and to the investigators. So that was overturned. Another thing that Richard Widom did in this case in the Los Angeles Superior Court is he claimed collateral estoppel against the Stockwell Firm, countersuing him for the liability that he put them under in assaulting and battering Lisa Kerner. Well, collateral estoppel means that you can't litigate against someone twice for the same issue. So, for example, if I sue somebody for stealing $50,000 from me and it turns out that they didn't do that and they're found not liable, I can't, through another venue or in a different suit, sue them for the same thing. Well, Widom claims that he was found factually innocent of these criminal charges, so Stockwell can't sue them again. And then he claimed that Lisa Kerner and the Stockwell firm are absolutely in privity. And in privity means that they're like the same person. They're so close together in their self-interest that they're like one in the same. Well, the Court of Appeal overturned the trial court's decision that they were in privity, Lisa Kerner and the Stockwell firm, and said they're not in privity. Just because George Wolverton assisted Lisa Kerner in communicating with the police, in filing the criminal charges, in her actions with the civil tort case, that doesn't mean they're in privity. And even if they have an attorney-client relationship, that doesn't make them in privity either. And here was another big to-do that was debated in the trial court. Lisa Kerner objected to answering certain questions because she claimed it went against her attorney-client privilege with George Wolverton. She claimed that George Wolverton was one of her attorneys and that she didn't have to answer certain questions that would invade that privilege. Well, the trial court said, no, there was no attorney-client relationship between Lisa Kerner and George Wolverton. Well, this went round and round and round, and I can see that most likely at the beginning of this case, George Wolverton didn't assert his attorney-client relationship with Lisa Kerner, and she didn't assert it either. They were co-workers. She was his boss. They worked for the same firm. He was acting as a friend towards her, probably even as a father figure towards her. So I think they were both unconscious for many, many, many months of the attorney-client privilege. And then finally, by 2011, George Wolverton asserted it and Lisa Kerner asserted it, but the trial court said, no, you have to answer these deposition questions, and you also have to submit these documents, because Richard Widom had filed motions compelling Lisa Kerner to answer certain questions and to produce documents. And Lisa Kerner and the Stockwell firm said, no, we're not going to, because we're asserting the attorney-client privilege. Well, the Court of Appeals went in favor of Stockwell and Lisa Kerner. So after this appeals court decision, many things were found reversed and in favor of Stockwell. What was found in favor of Stockwell and Lisa Kerner was the attorney-client privilege. They also denied Richard Widom collateral estoppel, and the reason they did that is because the appeals court's argument was you can't claim collateral estoppel on factual innocence when factual innocence means the charges never happened, the case never occurred, so poof, it disappears like Harry Houdini. So how can you claim not being litigated on the same thing twice if the first thing never happened? I hope I said that right. Okay, this is hairy, confusing, radical legalese and legal stuff. I mean, the motions and the maneuvers by Richard Widom, I mean, he's a crafty litigator. He's a real manipulative attorney, and reading this document had me pulling my hair out. What I think is more amazing is the human story behind it. On March 21st, 2011, Lisa Kerner alleges that Richard Widom broke into her house and beat her severely, beat her more severely than he did on March 1st, 2009. According to someone who is in the know and asked to remain anonymous, it's possible that what Richard Widom did is that he followed her in through her garage and slipped into her house that way on March 21st, 2011. She alleges that he beat her and she laid on the floor for 2 or 3 days. She was found because somebody couldn't get a hold of her and called the paramedics, and the paramedics broke in, found her, and took her to the hospital. She had a brain hemorrhage and consequently had brain surgery. This was 14 months ago, or 15 months ago, March 31st, 2011, till today, which is the 29th of June, is about 15 months. Lisa Kerner is still not working and is still not back at work. So, now this case is up for consideration with the California Supreme Court. I have just received information that that's a possibility. I haven't looked it up yet, but there's nothing on calendar at this time with the Los Angeles Superior Court, which is Stanley Mosque Courthouse at 111 North Hill Street. There's nothing on calendar. I looked on the calendar on the website, nothing there. Then I called the information assistant and she told me there's nothing on calendar yet. So, to be continued. Thank you for listening. I know this has been a long broadcast. My name is Lonce LaMon. I thank you for watching.